We all know what's making the headlines lately. The Supreme Court is currently hearing a case that's of great significance to LGBTQ plus community, the legal recognition of same-sex marriage. And guess what? It has already been 3 days since the Constitution bench started hearing this matter. So let's look into what's been happening and what all has happened in the Supreme Court till date. On 18th of April, the Constitution bench, headed by CJI D.Y. Chandrachud, along with Justices Sanjay Kishan Kaul, Ravindra Bhatt, Hima Kohli and P.S. Narasimha began hearing the petitions. The courtroom was filled with heated discussions on equality, privacy and dignity of the queer community, along with the rights that come with marriage equality. Interestingly, the court decided to limit itself to Special Marriage Act and decided not to go within the ambit of personal laws. On day one, Centre had questioned the maintainability of petitions and had also sought to implead all states. To be precise, Solicitor General Tushar Mehta had raised a thought-provoking question. Should the debate on the establishment of a socio-legal institution of marriage take place in a court or in a parliament? He further proposed that even if the court were to proceed, it must involve all states as parties to this matter. Without their involvement, the petitions would be invalid. However, the court was not inclined to decline the petitions on this ground of maintainability. Now, amidst this ongoing debate, Senior Advocate Mukul Rohatgi, representing the queer community, argued that he had the right to approach the Supreme Court under Article 32 regardless of Solicitor General's objections. The bench ultimately agreed, noting that the matter could be resolved without going into personal laws. On this same day, the Senior Advocate Menaka Guruswamy had asked for queer marriages to be included in the Hindu Marriage Act. However, the Chief Justice did not seem keen on discussing this issue at the moment. He suggested that changes should be made gradually, starting with the present situation and expanding over time. This way, Parliament can also keep up with the society's evolution. Coming over to the second day of the hearing, after Senior Advocate Mukul Rohatgi attempted to insert gender-neutral terms into the Special Marriage Act, the Supreme Court was faced with a puzzling dilemma. That is, which partner would be considered 18 years old and which would be 21 under the Special Marriage Act. Senior Advocate Singhvi, appearing for the queer community, also argued that the institution of marriage is sought after by many because it is essential to enjoy a family life, as it opens doors to adoption, surrogacy, interstate succession, tax exemptions, tax deductions, and even compassionate government appointments. Earlier, National Commission for Protection of Child Rights, that is NCPCR, had intervened by saying that allowing adoption to same-sex couples could affect children. But on the second day of hearing, the CJI pointed that even if a couple is in a gay relationship or a lesbian relationship, one of them can still adopt. Therefore, this argument that allowing same-sex marriage would have a negative psychological impact on the child is not supported by the fact that adoption is already allowed under the current law. Interestingly, while the National Commission for Protection of Child Rights has raised concerns about adoption of children by same-sex couples, the Delhi Commission for Protection of Child Rights has taken a progressive stance supporting adoption rights for such couples. In short, Senior Advocate Singhvi argued that marriage is crucial for many reasons beyond just love and companionship. And finally, let us come over to day 3. As we all know that under the Special Marriage Act, couples have to give 30 days notice before getting married and publicly announce their plans so that anyone who might object has a chance to speak up. While highlighting this issue, the petitioners argued that this requirement for advance notice of 30 days and public objections that is given under the Special Marriage Act violates privacy and autonomy rights. They also claimed that this provision exposes non-traditional couples to violence and threats from families and vigilant groups. The Constitution bench also expressed agreement with these concerns. Senior Advocate Dr. Abhishek Manu Singhvi argued that Hindu Marriage Act and personal laws do not mandate advance public notice for couples intending to marry. Then why does the Special Marriage Act? If it aims to benefit interfaith couples, then why does it impose such requirements? He asserted that the decision to marry should be a personal and private matter, irrespective of gender or sexual orientation. Senior Advocate Ramachandran also stated that this provision in the Special Marriage Act is regressive and unpleasant and should be removed for everyone. Also, for your information, in case you didn't know, in 2021, the Allahabad High Court had ruled that this requirement for advance notice in the Act is not obligatory, as it violates the fundamental right to privacy. Another argument common to all the opponents of marriage equality is that there's a big difference between straight couples and same-sex couples. That straight couples are better at raising children, and that's why only they should be allowed to get married. However, Chief Justice D.Y. Chandrachud addressed this concern and pointed out that even children of heterosexual couples face numerous challenges while growing up. For instance, what happens when a child sees domestic violence in their household? How can they possibly grow up in a normal atmosphere after witnessing their father's alcoholism and coming home every night to find their mother being beaten up? The point being that challenges that children face aren't exclusive to any particular group. But as usual, CJI was also fully aware of the risks of being trolled for his candid observations. Well, for now, the case is still ongoing, and during the hearing, the Chief Justice of India had orally remarked that this matter would be taken up even on miscellaneous days, similar to what had happened in the Ayodhya case. Because during the Ayodhya hearing, the Constitution bench had presided even on miscellaneous days, unlike the normal practice. And that brings us to the end of this video. There are many more aspects of this case that are yet to be explored, and LiveLaw will be providing regular updates to keep you informed. This was Apurva Pandita, and stay tuned to LiveLaw to stay up to date on all the latest developments of this case. Thanks for watching.